John Farrell with the Farrell Law Firm. Today we're going to talk about O.J. Simpson's last will and testament. But first, make sure you subscribe to the channel. We put out new videos almost every day. And make sure you hit the like button because, hey, every like helps. John Farrell with the Farrell Law Firm. To tell you a little bit about myself, I'm the author of Estate Planning for the Modern Family and was recently voted one of the top lawyers here in Cobb County, Georgia, along with the law firm being voted one of the top law firms here in Cobb County, Georgia. Today, we're going to talk about O.J. Simpson's estate and his last will and testament. For those of you who have been living under a rock, O.J. Simpson was an American football player whose off-the-field legal troubles overshadowed his on-the-field accomplishments. Although he was charged and acquitted of a double murder in the mid-1990s, the family of the victims obtained a very large civil judgment against him. O.J. Simpson passed away from cancer on April 10, 2024, and surprisingly, his last will and testament was filed for probate just a couple of days later on April 12th. It's surprising because wills aren't typically filed for probate until weeks or months after the person has passed away. But for the most part, anyone with an interest in the estate can file for probate, so maybe they thought they would go ahead and file the will to keep any other interested parties in filing for probate first. Well, I've read Simpson's will and we're going to go over some of the interesting things from the will. First, we're going to talk about how O.J. Simpson's last will and testament isn't your typical will. Second, we're going to talk about some of the provisions in his will that you typically just don't see in a last will and testament. And third, we're going to talk about how his debts might be paid through his estate. So, O.J. Simpson's last will and testament isn't your typical will. Typically, a last will and testament will dispose of the estate to the family of the deceased person. You've heard of things like this before. If I pass away, I want it to go to my spouse, but if my spouse isn't here, I want it to go to my kids. Or you'll see something like, I want my watch to go to my nephew and my bracelet to go to my daughter and a portion to go to my church. But Simpson's will is very different. Let's read the portion of his will that disposes of his estate. It says, I give, devise, and bequeath all of my property of every kind and character, wherever situated, whether community or separate, owned by me at my death, including any property over which I have a power of testamentary disposition, to the then acting trustee of the Orenthal Simpson Revocable Living Trust, dated January 25th, 2024, to be held, administered, and distributed according to the terms of said trust as it now exists or may be hereafter amended prior to my death. This type of will is something we in the industry call a pour-over will. The idea with this type of will is that prior to the person passing away, a trust was created where the person took all of their assets and put it into the name of the trust. The purpose of this type of trust is to keep your assets out of the probate court. After all, if the assets aren't in your name, then they won't have to go through probate when you pass away. The benefit, that is, whoever you've left your estate to can get their inheritances much quicker than the months and years it typically takes to go through probate. Another benefit is that your assets don't become part of the public record, so nobody has to know what you have and who's getting it. But the question is, if you have a trust and you've put your assets into the trust, then why would you need a last will and testament? Well, the reason is sometimes people forget to put everything they can into the trust. For example, imagine that you set up the trust and then 10 years go by and you decide to buy a cabin up in Blue Ridge. But when you buy that cabin, you buy it in your name and you forget to put it into the trust and then you pass away. Well, this type of will catches that cabin and pours it over into your trust. So it's more of a safety net than a will designed to dispose of your estate. So this tells me that if Simpson properly funded his trust, meaning he took all of his assets and put it into the trust, then there's not going to be much or any of his assets that have to go through probate and become part of the public record, which may mean that creditors will have a hard time getting access to his assets. Most wills aren't pour-over wills because most people don't set up trusts before they pass away. So in that sense, O.J. Simpson's will is not your typical last will and testament. Now, let's talk about something in Simpson's will that you don't typically find in a last will and testament. It's the provision about his final remains. His will reads, I direct that my remains be released to my personal representative to be disposed of at his or her discretion. However, my last wishes may be attached to this last will and testament. Those wishes regarding my final remains shall take precedence over this document for that purpose only. This is the funeral arrangements part of a will. You typically don't find something like that in a last will and testament these days for a very practical reason. The reason is that most of the time when a person passes away, the will isn't read until the funeral is long gone. So you wouldn't put something like that in a will unless you knew the will was going to be filed right away, which may have been the case with Simpson's will. Another interesting part of Simpson's will that you don't typically find in a last will and testament is the poison pill provision. It's not an unusual provision, but it is something that you don't see put into wills often. It's under section 3.3 of Simpson's will, and the relevant part reads something like this. If any, and there are a number of people listed here, desire to attack the will or have it declared null and void, then that person will receive $1 instead of what they should receive. This is what is called the inter rerum clause of the will, but we call it the poison pill provision in the industry. You might put this part in your will if you anticipated there might be litigation or dispute involving your estate. The idea is that it should cut down on family squabbles, making beneficiaries unwilling to fight for an estate for fear of losing their inheritance. Could he have anticipated that there would be litigation involving his estate? Considering his checkered past, he was probably advised to put the poison pill provision in. Finally, let's talk about that civil judgment the families had against O.J. Simpson, but now have against his estate. The way debts are paid in an estate depends on the nature of the debt. The debts are put into priority depending on what type of debt it is, and then paid in that order. While every state is different, a very typical order goes something like this. First, funeral expenses, then costs associated with administering the estate. Next, expenses of a last illness, and then unpaid taxes. Finally, you come to unpaid judgments and things like credit cards. So, if the estate doesn't have the assets to pay all of these things, they get paid in an order of priority until the money runs out. In this case, if there were any assets of the estate, judgment creditors are probably way down on the list of priority. But it will depend on a number of things such as which debts need to be paid or can be disputed and how much money is in the estate. That's really all we have to talk about today. If you've watched our videos for any amount of time, then you know what we do is we help people plan their estates. To do that, we've created a book called Estate Planning for the Modern Family. You're going to want to get a copy of this book, so I'm putting a link in the description below so you can order it online. It will tell you all about wills, trusts, powers of attorney, and the probate process. It also comes with a bonus. The bonus is if you have trouble sleeping at night, you can read it and it will get you right to sleep, so make sure you read it in the morning. If you want to learn a little bit more about the firm or maybe schedule a free consultation for yourself, give us a call at 678-809-4922. That's 678-809-4922. I'm also putting a link in the description below so you can reach out to us to schedule that free consultation. Alright, that's all we have for today. Make sure you subscribe to the channel because we put out new videos almost every day. And make sure you hit the like button because, hey, every like helps.